So today I'm doing a quick little teaching on wiretapping and the scope of it, what it should include, what it shouldn't include, and the reason that I'm doing it is because this has been the subject of something that I've been undergoing. The legality of it, questioning the legality of it has not been successfully undertaken. I literally asked Gemini and ChatGPT for successful overturns, and they could come up with no notes. They've The reason is because these warrants are requested under seal and they're granted by grand juries, which are governed by the district courts typically. Grand juries are sworn to secrecy. They're hosted by district attorneys, assistant U.S. attorneys. And sometimes they get a little bit skewed about what their role is in the justice system, and they somehow become prosecutors, many prosecutors, when they're supposed to be indifferent members of the pool of inhabitants of the region that are deciding the legality of these things and abuses and protecting citizens from the abuses of these tools. Because they want to be ingratiated with the U.S. attorneys and feel like they're a part of a story, which is why they so closely monitor their image in the media. No movies are allowed to use the CIA unless they favorably paint them, unless the story paints them in a favorable light. Same with the FBI. They're very protective with their image in the media. And this is why, because it can have an effect on these outcomes. And they have a winning record for a reason. So let's get into the legal scope. I'm just going to read you the research. The legal scope of a wiretap is governed by Title III of the 18th U.S. Code, subsection 2510 through 2522. Primary focus is to regulate the interception of the content of communications, meaning the actual substance of the conversation or electronic message. The requirement for Title III establishes the general prohibition against electronic surveillance and includes framework for obtaining a court order for the collection of communication content. Pen and register, trap, and trace, the scope of that. So a wiretap is when they are listening, storing communication sent to and from your device. Pen, register, trap, and trace is like every number sending messages to and from your phone is being recorded and collected and stored. So the legal scope for a pen trap is under Statute 18 of the U.S. Code, subsection 3121 through 3127.1. Focus regulates the collection of non-content addressing information related to communications. So records all outgoing information like phone numbers, dialed, IP addresses connected to. A trap and trace device records incoming information like phone numbers from which a call was placed. The requirement is an application and court order are necessary to authorize the use of this device, pen and register, or trap and trace device, included for use in collecting cell site information. right, so permissible versus unpermissible uses. And of course, we're getting a little bit of lag. So permissible deception versus impermissible fraud. So we all know that officers are allowed to deceive people in order to build a case. The problem comes in when they begin to deceive people in conjunction with wiretap. So assuming the identity of the owner of the line, sending fake messages, creating relationships that are false for the creation of cases that will subsequently also be false. So, permissible. Law enforcement may make false statements during questioning, use undercover identities they create, pose as criminals, buyers, or associates, communicate as themselves under an assumed identity. These are considered investigative deceptions, not fraud. Impermissible uses of deception. Law enforcement may not assume the identity of a real person, use another person's phone, number, or account, send messages as if they were the lawful owner, cause third parties to rely on that impersonation. This crosses the line into fraud, identity misuse, and unauthorized access. Why using another person's device is inherently fraudulent. Fraud does not require a financial loss alone. It requires a material misrepresentation, intent to deceive, reliance by another, resulting in harm or risk of harm. Using another person's device or account satisfies all four of these. The sender is misrepresented. The intent to deceive is the recipient. The recipient relies on the identity of the sender. Harm arises legal exposure, reputational damage, coerced statements, and fabricated evidence. No statutory authorization for impersonation. There's no federal statute that authorizes this conduct. Title III, the Wiretap Act, interception only, not impersonation. Pen and register, metadata only, metadata collection only. Stored Communications Act, disclosed by providers only. Rule 41 warrants seizure or search, not identity substitutions. Even with a warrant, officers may not become the person whose device is searched, nor may you put someone up to impersonating someone else and ignore the illegality as if you don't know the person is a fraud. Number 5, independent illegality. Important point. Even if a wiretap order existed, a warrant existed, an investigation was legitimate, impersonation remains independently unlawful. The method itself is illegal, regardless of the investigative purpose. Plain language conclusion: yes, defrauding others by using another person's device, phone number, or account is fraudulent and of itself, even if the law enforcement is otherwise permitted to deceive in investigations. That line, lying versus impersonating, is bright, not gray. This was prepared with the help of, the information portion was prepared with the help of ChatGPT. I took the liberty of finding some links for the wiretap laws that the government uses to obtain warrants. So, electronic surveillance manual procedures and case law forms. So, this takes you directly to justice.gov cites Criminal Legacy 2014 Electronic Surveillance Manual. And this manual holds 236 pages related to procedures and case laws in a PDF format. So it's literally their playbook on using those forms, how to get warrants, how to use them. This takes you to the justice.com archives website, Criminal Resources Manual, Electronic Surveillance Title III applications. So this gives you all of their how to prosecute, how to be a prosecutor for their various acts. But this gives you electronic surveillance application requirements for an attorney preparing. So as a defendant's attorney who has never successfully overturned a wiretap warrant, because we can't even find the data for it, this will give you a clue as to how they are apprehended, how they are issued, the amount of time that they get, 21 days. There should be notifying if it's a third-party owner. They should be notifying the owner, but they don't. How they get around that is AT&T will have a data breach, or T-Mobile will have a data breach. Their services will be down. There's been a data breach, so everyone's phone has been compromised. That's how they get around that. So electronic surveillance, Title III orders. This is how they get their orders and how they submit them. This is the case law that they use, all that good stuff. So in here, it's quite a meaty little, here's the statutory authority and legislative history, affidavit. I mean, it goes in on their specifics. And that's just a little bit of how that goes for you and for me and everyone who needs to be aware. NSA, I believe I've mentioned this before, is able to, there's another document here somewhere for the consensual monitoring of someone's files when they believe that they have consent. There's closed circuit monitoring, closed circuit television monitoring, consensual things, so you can notice the behaviors and the do's and the don'ts of what they're allowed to do, what they're not allowed to do. We need to be aware of these things, because when we're unaware of how to protect ourselves and our loved ones. Our children are being watched and monitored by these creeps and officers, and then you wonder why your kids get pulled over and basically arrested on marijuana offenses so they can take them somewhere and abuse them, you know what I'm saying, and bully them because they don't know their rights. So this is something that needs to be stopped, and it's of the utmost importance.